Thank you. Madam President, I have 6 unanimous consent requests for committees to meet during today's session of the Senate. They have the approval of the majority and minority leaders. I ask unanimous consent that these requests be agreed to and that these requests be printed in the record.
Without objection, so ordered.
Thank you. Madam President, I rise today to discuss what I think is one of the clearest threats to Americans' digital privacy and to introduce legislation that I think will go a long way toward addressing this problem. Madam President, Americans have valued and sought to protect their right to privacy for a long, long time, and so have the representatives that they have elected to be a part of this chamber. But in the past few decades, there has been a fundamental shift in the nature of our right to privacy and the privacy threats that we face. Because when I was young, when people talked about their right to privacy, they talked about protecting themselves from the government, from government intrusion. They asked, is the government keeping tabs on my political beliefs? Is it staying out of my family business? Today, we still need to worry about protecting our privacy from the government, but we also need to worry about protecting our privacy from private entities, from corporations that are obtaining and aggregating increasingly large amounts of our personal information. Nowhere is that need clearer and more urgent than on the internet. And within the internet ecosystem, I would argue that some of the most sensitive information out there comes from our phones. Smartphones are the future of the internet and can actually be more powerful than desktop computers from a decade ago. There will be more smartphones sold in 2012 than laptops and desktops combined. And there's a reason for that. These are incredible devices. Using a smartphone, a mother or a father can see his or her child and wish him or her good night, even if that child is half a world away. A smartphone can give a driver directions and can tell that driver where the nearest gas station is. Smartphones also enable emergency responders to find and respond to an accident in a matter of seconds. But the same technology that allows these wonderful, wonderful benefits also raises very clear privacy concerns. Our smartphones know where we are all the time. And unfortunately, the last 6 months have shown that our legal framework just hasn't kept up with technology and isn't protecting our privacy when we use these devices. Last December, an investigation by the Wall Street Journal revealed that of 101 top applications for Apple iPhones and Google Android devices, 47 disclosed information about a user's location to third parties without asking consent from the user. In April, security researchers discovered that for almost a year, Apple iPhone devices had been creating a detailed log of the different places the user had visited and stored that log on both the phone and every computer a user synced his or her device to, and did it in an unencrypted manner. That month, Americans learned that both iPhones and Androids were automatically transmitting location information back to Apple and Google. In the case of the iPhones, users had no clear way of knowing that this was happening. And in many cases, they actually had no way to stop it. In February, I became chairman of the Judiciary Committee's new subcommittee on privacy, technology, and the law. I decided to use my new role to dig down and find out more about smartphone privacy. When I learned of the events in April, I wrote Apple to ask what was going on, and in May, I held our first subcommittee hearing on the issue. We took testimony from the Department of Justice, the Federal Trade Commission, privacy advocates, technologists, representatives from app developers, and we took testimony from Apple and from Google. And I'll tell you, the more I learned about this problem, the more I became worried for consumers. I learned that an app on your phone can access an incredible amount of information on you. It can monitor your web browsing habits. It can access and read your address book. And of course, it can access your location. But in most cases, a user has no way of knowing that all of this information can be freely sent to third parties that the user has never heard of. A recent study of the top 340 free applications found that only 19% provided users with a link to a privacy policy. That's only about less than 1 in 5 apps. I also learned that our federal laws on this subject are a confusing hodgepodge full of gaps and loopholes, and that in many cases, our current federal laws explicitly allow wireless companies and companies like Apple and Google to disclose our location information to whomever they want. Let me give you an example. If I use my smartphone to make a phone call, my wireless company can't go out and give my location to third parties without getting my express consent. But if I use that same smartphone to search the internet, my wireless company can disclose my information to almost anyone they want. Here's another example. If I use a mapping application on my smartphone to find out where I am or to find the nearest supermarket, Apple and Google would have to ask my consent before telling third parties where I am. But if my same phone automatically transmits my location to one of these companies without my knowing it, then arguably under current federal law, again, these companies would likely be free to disclose my information to almost anyone they want. And you don't have to take my word for it. Over the past several months, I have asked privacy experts and officials from the Department of Justice and the Department of Commerce about these issues, and they have confirmed that this is, in fact, the case. This doesn't make sense. In fact, it's kind of a problem. But the most alarming thing I heard is that there are real-life consequences when we don't do enough to protect location information on our smartphones. The very first group that contacted me after I wrote my letter to Apple in April was the Minnesota Battered Women's Coalition. They told me that they have seen time and time again how smartphone location technology can be abused by batterers and stalkers. I asked the Minnesota Battered Women's Coalition to submit testimony for my hearing. 2 stories from their testimony jumped out at me. One was of a woman from St. Louis County, Minnesota. The presiding officer knows St. Louis County very well. It extends kind of from Duluth all the way up to the Canadian border. It's a huge county, actually. So recently, this woman had gone to a domestic violence program located in a county building. Within 5 minutes of entering the building, her abuser sent her a text message and asked her, "Why are you in the county building?" Soon after that, an advocate helped her get an order of protection against her abuser. To get that, she needed to go to the local courthouse. And soon after she filed the order of protection, the abuser texted her again. This time he asked, "Why did you go to the courthouse? Did you file for an order of protection against me?" Advocates later concluded that this woman's abuser was tracking her via a location tracking service on her phone. Another woman in Minnesota had a similar experience. When she secretly entered a domestic violence shelter, her abuser started sending her text messages asking her, "Why are you at a shelter?" In fact, he started calling taxi cabs to wait for her outside of the shelter at all hours of the day. Again, in this case, advocates realized that this woman's abuser was tracking her through an app on her phone. Madam President, my goal with the Privacy Subcommittee is to try to find a balance between the wonderful benefits of modern technology and our need to protect our privacy. And right now, when it comes to smartphone location technology, we have an imbalance because we're getting all the wonderful benefits, but we aren't keeping our privacy, and I think we can get both. This problem isn't going to fix itself, and let me tell you why I say that. After the hearing with Apple and Google, I asked representatives from each of those companies a simple question: will you require that the apps you sell have privacy policies? In fact, I also asked them this: even if you don't require that all the apps you sell have privacy policies, will you at least require privacy policies for just the apps that can get your location? Well, by last week, both companies had answered my questions. Let me summarize their answers. No. Madam President, I think Congress needs to act. And so that's why today I'm introducing the Location Privacy Protection Act of 2011. This piece of legislation is founded on a simple principle: that consumers have a right to know what information is being collected about them and how it is being used, and that they have a right to decide who will get that information and whom they can share it with. This bill will fill gaps and loopholes in current federal law to give consumers 4 simple protections. First, the bill says that anytime your wireless company or a company like Google or Apple or an app developer wants to get your location from your smartphone, they need to get your permission first. Second, if they want to give your information to a third party, they also need to get your permission. This doesn't mean that our smartphones are going to be clogged with permission screens. No, this can be done with one simple screen. My bill doesn't require a new permission screen from every subsequent company that gets your location. That would be impractical, and it just wouldn't be smart. So the third thing it does is require companies that collect and aggregate the location information from thousands of consumers. It would require them to take reasonable measures to protect that information from foreseeable threats. Finally, if a consumer writes one of these companies and asks, "Hey, do you have my location information?" that company has to answer that user yes or no. And if the user asks for his or her information to be deleted, the company has to honor that request. When I wrote the bill, I looked at the way other current digital privacy laws were being enforced. Most of them have what's called a private right of action that allows a consumer to get their day in court if their rights are violated. I know that many entrepreneurs find these burdensome, so I wrote the private right of action clause such that it would only kick in if no federal or state authority decides to act. I also included exceptions in the bill to make it easier for parents to keep track of their children, for companies to protect against fraud and use location information that's anonymous, and for emergency responders to get to the scene of an accident without any red tape. In fact, this bill doesn't cover law enforcement at all. It governs only what private companies do with our information and what companies they share it with. I'm proud to introduce this bill with my friend from Connecticut, Senator Blumenthal. I'm equally proud that the bill has the support for the Center for Democracy and Technology, Consumers Union, Consumer Action, the National Association of Consumer Advocates, the National Consumers League, the National Women's Law Center, the National Center for Victims of Crime, the National Network to End Domestic Violence, and the Minnesota Public Interest Research Group. And I ask unanimous consent that the text of the bill be included in the record.
Without objection, so ordered.
Thank you. This bill will bring us back to a better balance between the benefits of smartphone technology, and they are wonderful, and our right to privacy, which is basic. It was written with input from consumer advocates and industry alike. But even after today, I will continue to work with these groups to make sure that our bill is getting that balance right. I look forward to those conversations. And I thank the presiding officer, Madam President, and I yield the floor and would suggest the absence of a quorum.